On his last day at office, Chief Justice of India CJI Chandrachud will take a crucial decision. A 7-judge constitution bench of the Supreme Court, headed by the CJI, will decide on whether the Aligarh Muslim University can be considered a minority institution under Article 30 of the Constitution. Here is all you need to know about the case. So what's the case all about? The bench will decide on a reference that arose from a 2006 verdict of the Allahabad High Court, which held that the AMU, established through an imperial legislation in 1920, was not a minority institution. This issue was decided once before by the Supreme Court. In 1967, in the case of S. Aziz Pasha versus Union of India, a 5-judge constitution bench held that AMU was not a minority institution. It referred to the Aligarh Muslim University Act 1920, which established the university and held that AMU was neither established nor administered by the Muslim community, a requirement for minority educational institutions under Article 31 of the Constitution. An amendment to the AMU Act in 1981 stated that the university had been established by the Muslims of India. In 2005, the university, claiming minority status, reserved 50% of seats in postgraduate medical courses for Muslim students. In 2006, the Allahabad High Court struck down the reservation policy and the 1981 amendment holding that AMU was not a minority institution. This verdict was challenged in the Supreme Court, and in 2019, the case was referred to a 7-judge bench to decide if the verdict in S. Aziz Pasha versus Union of India required reconsideration. The centre, which withdrew from the appeal in 2016 and is now arguing against AMU's minority status, stated that AMU never possessed minority status. It said that when AMU was established in 1920 under an imperial legislation, it relinquished its religious status and has not been administered by the Muslim minority ever since. The centre also stated that S. Aziz Pasha versus Union of India was a case-specific decision and will not have any bearing on the minority status of other institutions. The petitioners, on the other hand, have argued that it does not matter who is in charge of the university's administration, and that Article 31 gives minorities the right to choose who is in charge of administration without affecting the minority status of the institution in question. They also argued that the court's decision in S. Aziz Pasha versus Union of India was contradictory, as the court had held that for university degrees to be valid, the university would have to be recognized by a statute, such as the AMU Act. However, the court also held that recognition by the statute would strip AMU of its minority status. Accepting this decision would impact the minority status of other minority institutions established under a law. So what will stripping of minority status mean for AMU? Without minority status, AMU will have to begin implementing reservation policies for both teachers and students in a similar manner as other public universities. If this status is granted, the university can provide up to 50% reservation for Muslim students. Currently, AMU does not allow any reservation policies of the state. However, it does have an internal reservation policy where 50% of seats are reserved for students who have studied in its affiliated schools or colleges.